Welcome to Boundless Accelerator Presents Toolkit Tuesday. My name is Temi Orekoya, and I'm the Startup Program Manager with Boundless Accelerator. And I'm so excited to be hosting this call today. I'm also joined by Alex Miller, our Program Coordinator at Boundless Accelerator. I'd also like to welcome our two friendly American Sign Language interpreters whose time today is graciously provided in kind by Asign, Liz and Jeanette. Thank you both for joining us, and thank you to Asign. Please feel free to spotlight the ASL interpreter if you need to. While I'm at it, I'd also like to thank our corporate sponsors, Ernst & Young, Synergenics, and Investing Guelph. We are very grateful for their support. Before beginning the session today, I would like us to give recognition to the land that Guelph is on. We acknowledge that many others here today may be on a different territory, so we invite and encourage each of you to give recognition to the land you occupy today and every day. As we gather for today's event, we are reminded that Guelph is situated on treaty land that is steeped in rich indigenous history and home to many First Nations, Inuit, and Métis people today. As a city, we have a responsibility for the stewardship of the land on which we live and work. Today, we acknowledge the Mississaugas of the Credit First Nation of the Anishinaabe peoples on whose traditional territory we are meeting. Today's webinar is called Boost Your Innovation, the Importance of IP and How IPON Can Help, with our guest Sonia Patenaude, Manager Intellectual Property at Intellectual Property Ontario, IPON. In case some of you are new to Boundless Accelerator, a quick background. Boundless Accelerator is one of 17 regional innovation centers in Ontario, and while we are located in Guelph, we serve the entire region of Southern Ontario and have one national program. This means that while most of our clients are relatively close by, we do have clients in BC, all the way to Nova Scotia, and all throughout Ontario. We work with our clients, supporting them throughout multiple stages of business growth, from startup to scale up, with lots of programs and workshops, networking opportunities, and even a trade show called the Ontario Innovation Expo. But now, more Sonia. Without further ado, I would like to introduce today's expert presenter, Sonia Patenaude. Sonia Patenaude is a manager of IP at Intellectual Property Ontario, IPON, and is a bilingual Canadian and US patent agent with hands-on experience in procuring, developing, protecting, and licensing IP. Most recently at the Department of National Defense, Sonia managed the IP licensing sub-program focused on promoting continued industry advancement and improving the program's performance. Sonia also spent 11 plus years at the National Research Council of Canada as an IP advisor and strategic contract advisor, and was a patent agent at Hexo Corp. Sonia has her Bachelor of Science in Biochemistry and her Doctor of Philosophy, that is PhD in Biochemistry. Should you have any questions for Sonia today, please use the Q&A feature, and we will monitor and ask your questions when the right moment appears during the presentation, or at the end during the organized question and answer period. Over to you, Sonia.
Thank you, Temi, for that wonderful introduction. And thank you to Boundless Accelerator for inviting me to speak with all of you today. I hope you find this informative and helpful, and I'll share my screen now to get so hopefully this will. All right, can everyone see this? Excellent. All right. I just need to get my mouse at the right place here. All right. Okay. So today we're going to talk about the importance of IP and how IPON can help you and your company achieve their goals using IP. And just as a quick opening note, I want to just remind you that this talk doesn't constitute legal advice. And if you have any questions that are particular to you, you should consult a legal advisor in order to have those questions answered. So what are we going to be talking about today? First, we're going to cover what intellectual property is, how it is protected, what IP strategy is, and why IP is important. I'll round out the talk with a quick overview of the IPON programs and services that are available to all of you, and then answer any questions that you may have. I will say that we have a lot of subject matter to cover in a short period of time. So this is obviously just going to be a high-level overview of most of those things. Obviously, some of the details won't be covered. And if you do have any questions, either you can ask them in the chat, or you can contact us at IPON, or again, talk to an independent legal advisor who can help you. So the first thing we're going to cover is, what is intellectual property? Well, as you know, intellectual property is a creation of the mind. It's all around you every day, and we don't often think about it. For example, intellectual property can be an invention. So for example, if you've had a coffee today and you made that coffee, you probably made it with an invention such as a French press or a mocha pot or a drip coffee maker, espresso machine. It also includes literary, scientific, or artistic works. So have you read an article online or seen a photograph or listened to a podcast? All of those things are intellectual property as well. Logos and names, well, we know that we're bombarded with those every day. You can see 2 logos on the bottom of this screen here, Boundless Accelerator or IP Ontario. Those constitute intellectual property as well. And then, design. So who has ever seen a product that they've instantly recognized just by its silhouette? For example, the silhouette of the Coke bottle. All of these things constitute intellectual property, and they are a little bit different than the intellectual property rights, which is the legal protection that is offered for intellectual property. Your IP rights serve as proof that you own the intellectual property. They are exclusive in the sense that they give you the right to prevent others from taking credit or from using your intellectual property. It offers you a monopoly for a limited amount of time. So they are time limited. They don't last forever generally. So intellectual property rights, there are many different kinds, and the ones that we will focus on today are the most common ones that you've probably heard about. Patents, copyrights, trademarks, industrial designs. Others that we will talk about, trade secrets and domain names, they're not official IP rights, but they do constitute intellectual property, and they can often form a very important part of your IP strategy. So let's start with patents. Patents protect inventions, and inventions can be products, machines, processes, chemical compositions, all sorts of things. They have to be new. In order to obtain patent protection on inventions, the inventions have to be new, so not previously known. They have to be not obvious to a person that is skilled in that area of technology, and they have to be useful in the sense that they work as they are intended to work. We can also obtain patents on improvements on all of these things, and many, many patents now are improvements on existing technologies. In Canada, we cannot, there are certain things that are not patentable, and these things are generally, they vary a little bit from country to country. For example, in Canada, we cannot patent methods of medical treatment or higher life forms. Many of you will have heard of the Harvard mouse. So this is the case where it was determined that we can't patent things like animals or people, for that matter. We also cannot patent discoveries or laws of nature, things that are mathematical formulas or purely mental operations. But there are many, many different technologies that can be patented across many, many different fields. The thing to keep in mind is some areas of technology will be tend to generate more patents than others. So for example, the telecom industry and electronics industries tend to generate more patents. And so this graphic here shows you the number of issued patents in the United States in 2021 in dark blue and in 2022 in light blue. And as you can see, most of these companies listed here, these are the largest, the companies that have obtained the most patents in the US in those years. So you can see that we're hovering around 6,300 patents issued for Samsung Electronics, which is in the top spot currently. That's a lot of patents. Now, there are various different reasons why they have so many patents. First, it's a very technical area. So they have been patenting things such as multi-camera solutions, 5G, 6G, and all of those things are found. They commercialize that technology in their Galaxy smartphones. So there's a lot of technology being patented there. There's also a lot of defensive publication or patenting happening in these electronics and telecom fields. So people patent things in order to prevent others from patenting those things. But all to say, there are some industries where you can patent many, many different things. However, don't be fooled into thinking that a patent has to be for something very complex. It can be a very simple invention. For example, the spider trap. I mean, if you've seen it in operation, there it is. You swoop up the spider and that's it. And a lot of people might think, well, this is a silly little invention and what's the point of patenting that? Well, you can buy this 2 for $40 at Lee Valley Tools. So there is, a market for that sort of thing. So even the simplest things can lead to a marketable and commercializable piece of IP. Next, we'll talk about copyrights. So copyrights protect things, and you'll recognize the copyright symbol, which I've had right there, the C and the circle. They protect literary works such as books, articles, reports, poems, that sort of thing. Dramatic works, which includes performances such as plays or shows. It can protect artistic works such as pictures, sculptures, paintings. And it also protects musical works, so songs, recordings. Copyright is also the means by which we protect computer software, recordings, broadcasts, and those things. The uniqueness of copyright is that unlike patents, copyright exists as soon as the work is created. It's automatic. There is no requirement to register copyright. However, you can voluntarily register your copyright, which can be helpful in cases of litigation. It proves ownership of the copyright and can have certain advantages. The copyright, once the work is created, you have copyright. That copyright is generally recognized globally through international agreements. So if you have copyright here, it would be recognized in the US. In Canada, copyright protection lasts for the life of the author plus 70 years. That's generally true. However, because IP rights in general are a country by country, they are determined country by country. Some countries have 50 years, some countries have 70. So you do have to look and see what the life of your copyright would be. Copyright includes 2 sort of parts to it: the economic rights, which is the exclusive rights that you can then license and monetize. And there are moral rights, which is the right of personality in their work. This has two parts as well. The right of association or attribution. So the right of an author or a creator to have their name associated with their work, or to remain anonymous should they choose to do so. The right, and also the right of integrity, which means that you cannot change a work without the author's or the creator's approval. So for example, if I look at the painting that's up on the screen right now, and I had a license to that, and I decided, well, I'm just going to reproduce that in grayscale. That is a very big change to the author's work. And so you would need permission from the author to do that. And that is called a waiver of moral rights. The author is completely able to approve or deny. He can choose to not give a waiver of moral rights, in which case you cannot change the work at all. Next, we'll talk about trademarks. Trademarks protect brands, essentially. You protect elements that distinguish your goods and services from those of other companies. So those elements can be all of the things that are listed here: words, designs, tastes, textures, scents, sounds, colors, shapes, moving images, holograms, methods of packaging. And they can be registered, in which case they are designated by the R in the circle, or they can be unregistered, in which case they're designated by TM. There are, again, advantages to registering your trademark. Generally, registered trademark will prove ownership. It will give you, your trademark will automatically be considered valid in case of a litigation matter, whereas that it may be a little bit more difficult if it is unregistered. Also, unregistered trademarks are typically geographically restricted in the sense that, it's not a national protection. There is a 10-year limit to trademark registration, the protection that's afforded by trademark. However, it can be renewed at the end of that 10-year period, and that renewal can happen indefinitely. So, you can register your company name now, and it can last forever if you'd like it to. So some industries or some types of businesses may benefit more from trademark protection than they would from patent protection, for example. And the example I've chosen to highlight to you today has to do with McDonald's. So McDonald's is a restaurant, as you all know, and restaurants are not they don't benefit as much from patents. There's a lot less that they can patent. Recipes are usually not patentable. So what do they rely on? They rely a lot on their brand. So McDonald's, for example, has over the years filed over 600 trademark registrations in Canada. And today, about 350 of those are active. So to give you an example of the things that McDonald's is protecting, they'll protect, obviously, the McDonald's name. This is a word mark. And they have 245 word marks in Canada. A word mark can also be a phrase. So, for example, I'm loving it. You can also then trademark a design. So, obviously, they have trademarked the Arches design. McDonald's has over 100 design trademarks in Canada as well. Interestingly enough, McDonald's has also trademarked the ABCED sound, and I think everybody can hear that in their head. I'm not going to sing it to you, but I will tell you that they have also trademarked ba-da-ba-ba-ba as a word mark in Canada. So you can't say ba-da-ba-ba-ba without attributing it to McDonald's. And finally, you'll see that you can and should maybe trademark combinations of things. So here we have the McDonald's word mark together with the Arches design. And you can also do multiple different versions of that, as McDonald's has done. Next, let's talk quickly about industrial designs. In Canada, if you have a registered industrial design, you should designate it by the D in a circle, as you have here. An industrial design protects the appearance of a product. So it can be shape, configuration, pattern, ornament, or a combination of those things. It does not protect function. So it is purely aesthetic. In order to be registered, industrial design has to be new and it has to be appealing to the eye. So that is a bit subjective. So you'll see that can vary. The industrial design protection will last for 15 years. It is not renewable. So to give you an idea that, yes, we can all think of some industrial designs that would be obvious to protect, but let me give you an example of maybe a technology area where it's not so obvious to protect what you have. For example, Becton Dickinson is a global medical device company, and they have file designs on many of their medical devices. For example, reagent plates, syringe barrels, specimen collection tubes, as well as cathode assemblies, and many, many, many others. So you can see that it doesn't necessarily have to be something that is, like a chair design or something like that. It can be in any different field. You can file an industrial design. So think about your technology and how that could be applicable to yours. Trade secrets, as I said, is not an IP right per se, but it is basically business information that derives its value from its secrecy. And that could be any sort of business information: formulas, recipes, compilations of information such as customer lists, methods, processes, even inventions that are undisclosed, that are not yet protected, but that you intend to protect later, or things that can't be reverse engineered. All those things can be considered trade secrets. There is no, as I mentioned, there is no formal registration for trade secrets in Canada. But it can be protected by contract and by tort and some common law. Some jurisdictions, such as the US, have enacted legislation that do protect trade secrets. And in order to have that trade secret recognized, you do have to hit certain milestones, or you certainly have to put in certain efforts in order to protect the trade secret, and you have to demonstrate that. And what kind of things or best practices are required in order to protect your trade secret? That can include many different things, including policies regarding your IP and confidential information. It should include keeping an inventory of your trade secrets, and certainly restricting access to those trade secrets to only those people who require the knowledge. You should also protect your trade secrets from disclosure and limit the disclosure of those trade secrets. When you do disclose, you should be using non-disclosure agreements in order to prevent further disclosure of the trade secrets by others. And finally, and possibly most importantly, you should really think about, not just think about, but actually train your employees to understand what their responsibilities are with respect to the company trade secrets. So I'll give you an example of a trade secret, and I will dispense with the Coca-Cola example and go with something completely different, which is WD-40. WD-40 was developed in 1953 as a protection against rust and corrosion. And the chemist who disclosed it did not patent the formula. And what he did was he sold it. And it has never been patented ever since. The formula was placed in a bank vault and remains there. The company that owns the WD formula mixes the substance in 3 different cities around the globe and then passes it on to its manufacturing partners. Now, to demonstrate the value that a trade secret can have, this is the company's only product. This is the company's only product. They market nothing else, just WD-40. And which of us has not gone to the store to buy a can of WD-40? So you can see that while it may seem that trade secrets is, let's not pay that much attention, trade secrets can be very, very valuable. The last one that we'll go through here is domain names. Now, domain names, again, is not an IP right on its own, but it is often treated as IP. Since it can provide a competitive advantage, particularly when you have a domain name that includes words or a combination of words that is used in a search engine, for example, to find a web page. Domain names are typically sold by domain registrars. So in Canada, for the .ca domain, that would be the Canadian Internet Registry Authority, so CIRA. A domain name, often you will see a domain name can contain a trademark. And if that trademark is registered, then the owner, and you are using a registered trademark in your domain name, the owner of the registered trademark can file a dispute in order to claw back that domain name. So it can be very important before adopting a trade name to look and see whether that is already registered as a registered trademark. On the flip side, you can protect a domain name by applying it by registering it as a trademark. So it goes both ways. Interestingly, domain names have become big business. In 2022, 1.1 billion domain names were registered worldwide. That's incredible. And as you can imagine, the most popular extension for domain names is .com. Surprisingly, it is followed in second place by .ca and then .org. So if you're thinking about what are the most popular domain names out there, the list looks like this. In 2022, these were the most popular domain names on the internet. I think all of us has gone to at least probably 3 or 4 of these in the last week even. For those of you who are curious, Baidu and Yandex, those are foreign search engines. So all of this, and then, okay, so great. Now we know what IP is, we know what the IP rights are. How do we protect it? Typically, a filing strategy and the process for protecting your IP will differ based on the type of IP that you're trying to protect. So is it a trademark? Is it going to be protected by trademark, or is it going to be protected by patent? The technological area is also important. So what works for biochemistry may be very different than what is typically used in a telecom industry as far as patent filing strategy is concerned, or IP filing strategy. Also, the size and stage of a company will make a big difference to how you approach a filing strategy. As you can imagine, a larger company would have more resources available, whereas a smaller company or a startup may have to be a little bit more selective. Before you get into, deciding on a filing strategy and, saying we're going to file everywhere, there are a lot of questions you should first consider. And some of them are, taking a step back and looking at the bigger picture. So first of all, do you have sufficient resources to support the protection process? That can be manpower, it can be budget, what have you. What is the purpose of obtaining IP protection? As we saw, in some industries, maybe it's just for defensive publication, or maybe you are trying to market a product, or maybe you are trying to build value for the company. You may have a different filing strategy based on all of those things. And then the question, obviously, of where the IP must be protected. Not where do we want to protect, but where must we protect it? And those things are usually linked to market, where it's manufactured, where the potential infringers are, and then finally, what is your budget? Because as we know, IP protection can be quite expensive, and so budget is important. I'm going to show you here an example of a filing strategy and timeline. This is more typical in an industry where things don't necessarily move so fast. So biotech, this is a very typical type of filing strategy, whereas this would not work necessarily in the telecom industry. So if we first look here at the beginning, I don't know if you can see no, you can't see. At the beginning, we have the creation of the invention. That's the little gears. You'll take some time here to evaluate your invention, to see if anybody else has done it, to see what is out there, and determine how you're going to file this. You should probably, and most recommended, to consult a service provider who can help you draft the patent application. And then we'll file you, in this particular scenario, we're filing a U.S. provisional. A U.S. provisional is an application that expires after a year. It is never published on its own. And so this is basically a year in which you can further develop the technology, You can seek partners or licensees for your technology. You can continue to identify the proper market for it, but it essentially extends the time for 12 months. At the 12-month mark, you want to file a regular application. And in this case, in this type of filing strategy, we're filing what's called a Patent Cooperation Treaty application. It's a PCT application. This is the world patent that sometimes you'll hear it referred to. It's not on its own ever going to be a issued patent. What it does is it holds a place. It's a placeholder for all of the countries that have ratified the PCT. So 150 plus countries. You have the option to file your patent in all of these countries. Now, this is again something where you buy some time. So at the 12-month mark, you file your PCT application. At the 18-month mark, that will get published. Now, this is the point in time where your application will become public and the world can see what your invention is. You'll have some back and forth with the patent office. You can have an initial evaluation of whether your technology your invention is new or useful or non-obvious. They will give you initial sense of that. At the 30-month mark, this is the important part. This is the part where you will select which countries you want patent protection in. So that placeholder at the 12-month mark comes into play here. You can select any of the 150 plus countries that adhere to the PCT. So you file your application in each of those individual countries. And then you have a back and forth with each of those individual patent offices, and they will evaluate according to their own criteria whether your invention is new and useful and not obvious. Once that process goes back and forth, hopefully your invention will be found acceptable, new, useful, non-obvious, and you will be issued a patent. Now, I know that in this slide, I've shown it as everybody ends at the same time. That is not, in fact, the case. In some countries, prosecution will be quick and could be 2 years or 1 year. In other countries, it could take 5 years. It really is dependent on the jurisdiction. I will note that the national entry point at the 30 months, that is a very expensive point in time because you are filing in each of the countries, which incurs its own fees. In some cases, you may need translations. That includes a lot of fees as well. So one of the advantages of using the PCT process is that you do get to buy time to collect those funds in order to enter to do the national entry in all the countries that you're interested in. This could look a lot different. It could be a lot shorter. And I've shown it on the next slide. I'll just show you really quickly. It could look like this. So instead of doing a PCT process, you could simply go from a provisional application to filing directly in all the countries. You could even shorten this by, instead of filing a provisional application, file directly in all the countries. But you can see that the closer you get to the 0 time mark, the more you're spending money right away. So sometimes it can be advantageous. It can give you a chance to raise some additional funds in order to protect your patentable technology. I'll have a really quick overview of the trademark application process. I am not a trademark expert. I am a patent agent, but I can tell you that like patents, you have to file an application for your trademark. You'll have a back and forth with the IP office, and then they will make a determination as to whether they will accept or reject the registration. So in Canada, you could file with the Canadian Patent Office and go through that process. Or you have the option to use the Madrid system. Now, the Madrid system in trademarks is analogous to the PCT in patents in that it's an international system. The trademark office will send your application to the International Bureau, which will then communicate that to all the different countries in which you are interested in filing your trademark application. So you do have a very similar process of international, and then you can choose which countries you want to enter. There are certain advantages and disadvantages to that. It's a global system, and you are dealing with but one international office, so that makes it a little bit easier. It can be cost effective if you're filing in, about 10 or more jurisdictions at a time. So how do we put all of this together? What is IP, filing strategy? How does this all come together? Well, IP strategy, what is it? First of all, well, it is really a set of IP-based decisions that can give you a competitive advantage. So it's a plan on how you can develop, acquire, protect, and manage, as well as leverage your IP assets. It should align with your business goals. So if the business is trying to achieve X, how does your IP strategy work to help achieve those goals? So your IP strategy should describe IP management through all of its phases. Development, so that should mesh with your innovation strategy, which brings together, your R&D plan, your resource allocation, your partnership approaches, etc. And as well as your protection and maintenance of your IP. So your development phase links to this phase through the disclosure of an innovation within the company. If you've developed something, then it moves into a protection and maintenance phase. What is the plan for that? So that includes all of your filing strategy, your budgeting, all of these things. And then commercialization and monetization of your IP. So how are you going to generate revenue for the company using the IP? It should also establish how IP is managed in view of the business strategy. So how does that IP management that we just talked about, how does that build the value for the company? How does it help the company advance towards its business goals? So those things should all be addressed in your IP strategy. Now, how do you go about building that? It can be really complicated because there are a lot of things to consider. If you fail to look at the big picture, let's not get funneled into a certain, let's not concentrate on only filing strategy, because if you have only a filing strategy, you do not have an IP strategy. You only have a filing strategy. So take a step back and think about your needs and goals. What do you need your IP strategy to do in order to achieve those needs and goals? So ask yourself a whole bunch of questions. How does the IP strategy fit within your innovation strategy? How does it drive your innovation further? That whole creation process and then filing and protecting of the IP, how can you take that and then funnel it back into the creative process so that it can keep driving your innovation? How does it maximize the effectiveness and improve the success rate of your innovation strategy? You should also think about how the organization's objectives, what are the organization's objectives and how the IP strategy can actually contribute to that. So what are you trying to achieve? Are you trying to attract VC funding? Are you trying to bring a product to market? Are you trying to go to IPO? What is it that you're trying to achieve, and what needs to happen with your IP strategy in order to achieve that? Do you have the IP that you require in order to achieve those objectives? Or do you need to develop more? Or do you need to acquire more, whether that be by buying IP or licensing IP? What forms of IP can you rely on? Trademarks, patents, where do you need that protection in order to achieve the goals that you're trying to achieve? And what third-party IP is relevant to you and your business? Is there somebody who owns a patent that is in your way that you would be infringing if you were to go forward? If so, what do you do about that? How do you build that into your IP strategy? Are you going to license it? Or are you going to design around it? All those things need to be thought about. How can IP address your internal needs or inform the market position? So is there something that you have that could, some of the IP doesn't necessarily have to pertain to bringing your product to market. It just can make your internal processes more efficient. How does that do that? Also ask yourself if there are any barriers to that. You know, do you have any internal barriers? Do you have all the necessary IP intelligence that you need? Do you have landscape intelligence to know where to focus your IP or where to drive your business so that there is some white space for you to operate in? How can exploiting the IP lead to achieving your goals? So what IP should you leverage? What should you be licensing out? What should you be keeping for yourself? Are there any partnerships that you could establish that would help you in development of your IP or in bringing your product to market? Would licensing contribute to your success? All of these things should be thought about. And finally, and again, possibly most importantly, how are you going to communicate this IP strategy internally? How are your employees going to know where you are going with your IP? And that can be through IP policy and procedures. It can be through IP awareness training for both employees and for management. So IP strategy and optimal outcome, you want to try to, who doesn't like a Venn diagram, right? You want to try to get the IP rights that are available, and you want to be in the intersection there in the middle with the little star. You want IP rights that are available, that answer a market or commercial need, and that show that your product is different or your service is different than those of others. And again, it's very important to realize that your IP position, it will change over time. So you need to revise your IP strategy as time goes on. And I'm just going to go back to a chart that I showed you earlier, which is this chart here. Now, I don't know how many of you noticed, but IBM was in second place in 2022 with about 4,400 patents issued in the US. The year before, they were at 8,600. So it went down 49% in 1 year. Now, that would be alarming to a lot of people when you look at that and go, oh my goodness, what happened here? Well, what IBM did for 29 years, IBM held the #1 spot for the number of issued patents in the US, 29 years running. 2022 was the first time that they were not in the #1 spot. They decreased 49% the number of issued patents over the year before. And the reason for that is that in 2020, IBM refocused their business and they took a more selective approach to patenting. The quote from IBM is that they turned their talent and resources towards achieving high quality, high impact advancements in specific areas of hybrid cloud, data and AI, automation, security, semiconductors, and quantum computing. That approach required balancing trade secrets and patents alongside with open innovation. And because they're more complicated areas where advancement is possibly slower and requires more resources, they've seen a slowdown in their patenting, and because they are being more selective. And that's okay. And if Big Blue can take the time to readjust their patent strategy at the size they are, then your companies, you can certainly feel free and should adjust your patent strategy or your IP filing strategy or IP strategy as required. So why is IP important? I think most of those questions will kind of have been addressed by now, just by going through what different types of IP are and what your patent strategy or IP strategy is trying to answer. But, IP can protect your business assets. It can and you have different types of IP rights that will protect different aspects of your products and services. It can be in the manufacturing or in the actual product itself. Different things protect different parts of your technology. It can transform intellectual outputs, so something that is sort of intangible into a commercial asset. 90% of a startup's value can be in its IP. And if you don't protect that, what value do you have left? It can open up different marketplaces and opportunities for you in that if you partner with someone that incorporates your IP, then that can help you reach more markets, etc. It can discourage potential infringers, and also obviously enhance corporate value and attract funding and other partners. Some stats on the difference between companies with patents and without patents, and the venture capital type of funding that they have attracted. As you can see, there is a much larger portion of companies with patents than without patents that have benefited from that. IPON programs and services that can help you, I'm going to go over really fast because I know that we are approaching the time. IPON has various services that we provide. That can include foundational IP education, and that is available to anyone. Anyone in the public, you can access that. So that is basic IP education, a lot of the things that we've talked about today, but in more detail. We also have free public events and various online resources that you can access. Those companies that are clients of IPON also have access to many other different services, including IP benchmarking, which requires you to fill out a survey, and then you will obtain a report that outlines maybe areas of particular need that you need to address. So various, various weak areas of your IP strategy or things that need to be addressed with your IP health and awareness. We also have IP intelligence / landscaping services where we have different reports on different industries that are available to our clients. We have a one-on-one mentoring program service where we match the companies up with a mentor in a particular area of need that the client has identified. So if you have a need in branding or IP strategy or something like that, we match you up with a mentor that has expertise in that area, and you can have up to, I believe it's 12 hours of mentorship per month with that mentor. Obviously, we have IP funding, so an initial $35,000, which can cover a variety of different IP services, excluding litigation, is one notable exclusion. But what we do is we reimburse the clients 80%. So 80% of your IP fees up to $35,000. And there is a likelihood of additional funding calls up to $100,000. So that $35,000 could be expanded. We also have upcoming advanced education and Tiger Team services. So advanced education, a little bit more in depth on various topics. And Tiger Team is if you have a very acute need. So someone has received a cease and desist letter and doesn't know what to do. So there will be a small team put together, and they can have a little bit of advice received from them on that particular topic. These services are currently available through two programs which are currently accepting applications. So we have our IP Bootcamp and our partner program. The IP Bootcamp, the main difference that I will tell you about right now is IP Bootcamp companies can apply to directly, whereas partner program, the regional innovation centers such as Boundless Accelerator would provide a referral to IPON, and then the company would receive an invitation to fill out an application and become a partner. The third program that will be open soon is a self-guided type program where you have access to the advanced education as well as funding calls. And so there are other IP funders out there currently, many, and I've listed a few here for your, if you have any other needs, and you can always have a look at these different IP funders. And I have exceeded my time by a few minutes, but I think we've managed to put a lot of information in a very short amount of time. So if you have any questions, I don't know if there are any questions in the chat currently.
Yeah, I have a couple for you.
Okay.
Okay, so there are a few that came in before the actual session had started today. So the first one was just wondering if you could help me navigate video game IP and what is protected as my IP, even though we do not have a patent.
Right, so that can be a little bit, first of all, as I said earlier, we don't offer legal advice. So it's very difficult, and it's very difficult to give generalities with respect to video game IP. But when we're talking about video games, a lot of times you're talking about copyright. And so there are some particularities with copyright and personality rights. So if you create something and whether somebody else can use that is a big question, and is a lot of subjective analysis. I'm not a copyright expert by any means, but there are definitely service providers that are out there that can help with that. It depends also on what exactly are we talking about? The graphics portion? Are we talking about the coding portion? That needs to be taken into account. If there are specific questions, I would suggest probably the best thing to do would be to send an email to the services at IPON, and there will be somebody who can answer the question of, maybe where to go. Probably a service provider would be a good place to start, simply because it sounds like there are some very specific questions about maybe misuse of someone's IP there.
Okay, perfect. Another one is, what are the AI specific factors to consider when patenting an AI field, plus steps to receive IP funding?
Well, the AI field, as you can imagine, is not quite right up my alley, though I can tell you that currently the AI field is a priority sector for IPON. And so at this moment, as I mentioned, our application process for both the bootcamp and the partner program are open, and the AI sector is priority. So anybody who is in the AI sector can apply and would be considered eligible based on the sector eligibility. So that's the funding piece right now. As I mentioned, we have $35,000 available for IP services initially, and that can be extended to $100,000 when the additional funding calls come out. With respect to AI itself, I think there are a lot of open questions as to, what, and I assume here that we're talking about the software side, or not the generating new IP using AI, so not Chat GPT or something like that. We do have we have seen a lot of companies who do incorporate AI, and I am not going to even attempt to tell you what particular kernels are being looked for in the AI sector, as it is not at all my area of expertise. But there is a lot of AI out there. There is a lot of things that are not settled yet. There are a lot of cases that are going through various court systems in various jurisdictions. So it's very up in the air. I think there's a lot of uncertainty around that at this point. But again, on the technical side, I really recommend maybe talking to somebody who has more technical expertise there than I do.
Okay. Since we're getting closer to the end, I know we still have 8 minutes. We'll probably only get a few more done. There are a couple still coming into the chat. So another one for you from somebody was, for IP for food beverage producers, is the IP they need to worry about mainly based around trademarking your brand? Is it true you cannot copyright a recipe?
Okay, so copyright does not really, so if you have a recipe and you write it out, it's the presentation of the recipe, right? That is what is copyrighted. It won't prevent somebody from making that recipe, if you will. It will prevent somebody from photocopying the recipe that you've written and distributing that. So with respect to a food and beverage industry, now it all depends. Generally speaking, a recipe is not really something that can be patented unless there is something surprising in that recipe. So if it's just, if you're making cake and you put flour and baking powder and all the usual ingredients with maybe, something to put flavor in, well, if you put mint in it, you expect it to be minty. So it can be challenging to patent a recipe for food or something like that. However, it depends what area of the food. If we're talking a restaurant, you're probably looking a lot more at trademark. So for example, McDonald's. McDonald's has a handful of patents, but they are mostly to processes and machines, not to the food itself. They have industrial designs, but that does not cover what they are making. Everything is in the brand. Everything's in the McDonald's brand. So if you're looking at a restaurant, you might not have a lot of patent type IP. You might be relying more on your trademark brand. But if you're looking at the manufacturing area, maybe there is some way in which you are manufacturing the food product or the drink that is new and improved. So it really depends on the specifics of the situation and what area you are in.
Okay. The next question is, could you provide any specific steps and considerations involved in patenting AI algorithms, and what is the usual cost and timeline to draft US provincial applications before publishing research papers?
Oh boy, there's a lot there.
Yeah.
So let's address. I'll address the publication aspect first, because we haven't really talked about that. But if you're looking at patenting something that is very important to know is it has to be it's best if it's not disclosed at all ever before you file your patent application. So if you're going to publish something in a research paper, some jurisdictions will give you 1 year after that publication in which to submit your patent application, because after that period of time, it will be considered known because you've published it in the particular field in which you're operating. So it is a known thing that is published and it's available to the public. So what you prefer to do is to file your patent application and then publish. Now, that said, yes, some countries will give you that, what they call a grace period to file your patent application, and some countries do not. As soon as you've published that without filing your patent application, it's game over. It is available to the public, and therefore you will never be able to obtain patent protection on that thing. So it's very important to speak to someone before you do anything with whatever it is that you've invented. Whatever invention you have, really be aware that public disclosure can be a big problem. Even in the countries where you do have that grace period, if you publish more than what you put in your patent application, that can also be a very big problem. So it's really important to talk to your service provider before you go and publish. And if you have already published and you want to file a patent application, then it's also important to determine where that's available and what you will be able to do. Very, very important. With respect to patenting AI algorithms, again, not my area of expertise. Highly recommend talking to somebody who is an expert in that area. I can tell you that patenting algorithms is probably going to be complicated in itself. There are very specific requirements with respect to software and that sort of algorithmic area. Some things can be patented, some things cannot, and there are very specific requirements if it is patentable. So important to talk to a service provider who can then say, okay, well, do you have these things? If not, what are the options? Can you keep it as a trade secret? Is there something that you can do in order, some alternative that you can have in order to protect it? Certainly when we're talking about software, the copyright is always a protection for that software.
Okay, perfect. I think Temi was just going to say a quick goodbye just because we're at the end of our time here.
Okay.
Awesome. Thank you so much, Sonia. I really enjoyed the conversation, and thank you so much for getting through the amount of material you had to get through and answering the questions as well. We have now come to the end of today's session. And I will just ask that you please fill the feedback form that Alex has placed in the chat section. And if anybody would want to connect with Sonia with IPON, you can reach out to Alex or myself for an introduction, and we can just walk you through the different options that we have available. Alternatively, Alex has also fixed in the email address for the services at IPON email. And then you can just check in on whatever follow-up questions that you have directly. So please, like I said, fill the feedback form. We will also just want to get your feedback on how this Toolkit Tuesday session went and the series in general. If there's a topic you'd like us to present on, I see there have been a lot of questions. So if you want us to do another session on IP, please let us know. Feel free to follow us on social media too, and post about your experience with us at Boundless Accelerator. Again, a sincere thank you to Sonia, to our Assign interpreters, Liz and Jeanette, to our sponsors, to Alex, Shona, and to all of you. Thanks for being here today. Have a great afternoon and come back again soon. Thank you. Bye.
All right. Thank you.